Welcome back to the Straight Talking Law podcast. In our last episode, we looked at what happens if someone is accused of a sexual offence and the steps they should take straight away. Today, we're focusing on another area we see a lot in practice: drug offences. For many people, this comes completely out of the blue. What might start as a stop and search, or even just a knock at the door, can quickly escalate into something much more serious. Clients often say they feel like they've lost control of the situation before they've even had a chance to understand what's happening. So today, I'm going to put myself in that position and ask the kinds of questions someone might have if they suddenly found themselves being accused of a drug offence. And to guide us through that, I'm joined by Michael Horne. Okay, so let's start at the beginning.
Michael, if I was being accused of a drug offence, what's usually already happened before I even hear from the police? Would I be arrested straight away, or does it tend to start earlier than that?
It all depends on the kind of drug offence that you're talking about, John, because if you're in the business of supplying drugs, almost always by the time that you get arrested, there is intelligence against you. The police have been following people, getting tips from other people. They know where you're getting your drugs from. They know where you're selling them. And it depends again on the size of the investigation. They might be after other people that are supplying you. So if you are supplying drugs, clearly you shouldn't be, but if you are and the police arrest you, the chances are they've got intelligence against you already. If it is the case that you are in that part of the world where you are dealing drugs, then really you ought to have met your lawyer beforehand. Don't leave it to luck. And if you are going to make your money that way, then be prepared, because that knock on the door is almost certainly coming. If it's the case where you're doing something else wrong, don't know, speeding, or some other offence, perhaps no insurance on your car or the lights don't work, and the police pull you over and they've reason to believe, so there's reasonable suspicion that you might be under the influence, alcohol, or in this case, drugs, then they can test you. They can roadside test you. And if it's the case that you show positive, then they can arrest you. They can take you to the police station where you are then asked to give either blood or other samples. And if you refuse, then that's an offence in itself. If it's the case that you are stopped on the side of the road and they don't suspect you to be under the influence of drugs, but they've got reasonable belief, that may be a tip-off. It may be that perhaps they've seen you go to an area where they are already observing people selling drugs and they know that you must have bought drugs, then they can search your car. But they need that reasonable belief that you have drugs or some other criminal content, something illegal in your car. So if that happens and the police stop you, if you're just a user, it's for personal use, then almost certainly the best way forwards is to just be open and honest. But you need to be extremely careful. We've been through videos before, John, where I've explained you ought not really just be speaking to the police. So you shouldn't be making admissions to them in any way. You need to speak with a solicitor first. And if on the side of the road the police want to question you, then they're going to arrest you and they're going to take you back to the police station. There's a lot of pressure on people. They just want to get out of the police station. And in that regard, they think, well, look, I don't think I've done anything wrong, or what I have done is something very minor. So I'll just have the interview with the police without a solicitor. John, that's a really bad move indeed. You need to have a solicitor with you. And again, we've talked about it before, John, haven't we? If you go along to the police station, they will give you a free solicitor, a duty solicitor. You can trust those guys. They know what they're doing. They are not connected to the police, even though they're at the police station. But if you already know a solicitor, a privately funded solicitor, then you can ask for that solicitor to be called and to attend the police station to advise you. I'm asked often about whether or not being arrested and then interviewed, or invited to the police station for an interview, whether the one is more serious than the other. And the answer is no. If you're in interview with the police, you're under caution. And that means anything that you say can and will be used in evidence against you. Be careful about your admissions. And John, of course, when you're arrested and the police might want to take your telephone, don't volunteer the PIN. They can ask for it, but unless it's demanded under a specific provision of the law, you don't have to give it. But if you give your PIN to your phone or your other devices, then the police can look on them. And if they look on them and they find something that's criminal but isn't associated with the reason for arrest, they can further arrest you. So, unless advised to do so by a solicitor, don't give the police your PIN.
Thanks, Michael. That's really helpful. If I was then searched, whether that's on the street or at home, what are the police actually allowed to look through? And in that moment, what rights would I have?
John, thanks for that. I think that you need to understand the difference between being searched, whether you're searched on the street or at home. Really, to have the police at your home, it's gone a little bit further than being on the street. So if the police stop you on the street and they suspect that you might have drugs on you, then they can search you there and then. If you have drugs and they deem it to be an arrestable offence, they can arrest you. You'll then go to the police station, and at the police station, a superior officer can then authorise a search warrant for your property, which means that they can then go back to your place of residence where you live, and they can search your areas. And a lot of people get a little bit confused about this. If the police turn up at a property that's, say, shared, they cannot just go through every room. They can only go to the rooms that you have got access to. Say your bedroom, your living room, or a shared living room. They can't just go in everybody else's rooms. And if they do, and they find something there, then that evidence can be inadmissible in court against you. So being searched at home or on the street or at the police station, really the advice is don't speak to the police. If they're searching you and they find something, they're going to find it. Even just a small comment like, oh goodness, I knew you'd find that, is really bad for you. Or, oh, I'm really sorry about that. That's really bad for you. You just confirm your name and your address, let the police do what they want to do, but then you ask for a solicitor and you wait. If it takes a little while for your solicitor to get there, just dig in, have a cup of tea, stay in the cell that they put you in. You're allowed a phone call to tell somebody that you're there so nobody worries about you, but you dig in, you wait for the solicitor.
Okay, so Michael, if drugs were found on me or in my property, how do the police decide whether I'm being treated as simple possession or something more serious like intent to supply?
Of course, that's going to be down to not just the quantity of the drugs, but how they're packaged. So if the police come into your home and there's some drugs there, some cannabis or some Class A drugs, and clearly it's for your own personal use, doesn't mean that you won't be arrested for that, especially if they're investigating another crime. They'll arrest you for everything. And later on, the Crown Prosecution Service, the CPS, will decide what charges are brought against you and which are not. And in that regard, they'll be looking at the quantity of the drugs and the kind of drugs. If it's just for personal use, the chances are you won't be charged. And if you are charged, you'll be charged along with the main offence of something else that the police are investigating. It's entirely different, isn't it? If you've got scales at home and there's some trace on those scales of those drugs, or if there are packages at home where clearly you've sent them out in different proportions, and especially if they find money as well at home. All of those things add together mean that you're supplying, and that's really very, very dangerous. You should not be there. Of course, you have to think about what supply means. So if you're going out for the weekend with your partner or your friends and you buy some drugs from somebody and you give those drugs to your friends, you've supplied it. Doesn't mean that you have to be paid. It just means that you've supplied drugs to those other people. And so you are committing a crime, a criminal offence. So be careful what it is that you're doing. Be careful what it is that you're admitting to the police. Because you don't want to say, oh yeah, those drugs, I bought them to give them to my friends, thinking that that removes the allegation of supply. It simply doesn't. And so when the police, and specifically the Crown Prosecution Service, are looking at this, they're going to look at the criminality generally, What is it that you're involved in? If your house is absolutely jam-packed with stolen property and you're receiving it and you're selling it on, or you're the person that's been stealing it, and you've got drugs as well, you can expect the whole thing to be packaged up together. If you've got, I don't know, scales, and your defense is, I weigh my drugs in order to wean myself off, then that may well be a defense to possession with intent to supply, because your defense would be, I'm setting out on those scales what I will use myself coming forwards. But again, this is all about the evidence that surrounds why you've been arrested. And if you've a wad of money next to your scales or in your possession, then saying you're setting out the drugs in these packages for you to use in the future to wean yourself off or manage what you're taking in the way of drugs, that money alongside is going to be circumstantial evidence that joins very, very closely to the drugs, which means probably you're going to be facing an allegation of possession with intent to supply. You'll lose your money, you'll lose your drugs, you may lose your liberty, which means you may go to prison, but certainly you're going to be facing the wrong end of the law.
So it's not just about the amount, it's everything around the situation.
John, that's absolutely right. As we've said before, if you are a criminal and you're receiving stolen goods and the police come and search your property looking for stolen goods, perhaps, I don't know, there's been a tip-off, or perhaps you've been arrested for burglary or theft or something like that, and they come into your property, then all of those other elements, the scales, the drugs, the money, the paraphernalia, the use of drugs or associated equipment with them, is going to be enough for the police then to come back to you, even if you've already been arrested, and rearrest you and then interview you over the possession of the drugs. And if there are those bags, if there are those weighed out amounts or money at home, they're going to be asking you about possession. Therefore, you would have possession with intent to supply it.
Michael, let me put a scenario to you. If drugs were found, but I'm saying they're not mine, how would the law treat that? Am I automatically in trouble just because they were near me?
I think the case of being near you, John, doesn't do it. If, for example, I'm sat in a pub and on the table next to me are drugs, possibly the guy who sat on the same bench as me but facing a slightly different way and clearly not with me, but the drugs were there, could the police allege that I was in control of those drugs? Could the police allege that I was in possession of them? And of course, the evidential burden for the police or the prosecution would be to show that I was in fact in control or a part of the criminal activity of either holding, so possession, or intent to supply those drugs. So the further you are away from the true facts of the case, the better your defense will be. But if you're there and it's happening around you, then most certainly the police could investigate you, asking you, what do you know about this? In the hopes either that they catch you, that you are a part of this, or you say, no, it wasn't me, it was him. I saw him or her doing these things. And then they will have evidence from you, which assists them in the investigation against others. So you have to be very careful what you're saying and what you're doing. And certainly, again, I warn you about the admissions, in that you need to be careful what you're saying, because a simple statement can be an admission and you need a solicitor. You shouldn't be speaking to the police without a solicitor. Doesn't matter how nice those police officers appear to be, they're there investigating a crime. And when we talk with people, and I'm asked quite regularly about this, how big does this have to be before it draws in everybody else around it? Well, the bigger the organisation of the supply of those drugs, the more likely it is to capture those on the peripheral. So people who might be involved, I don't know, giving a friend a lift. Because if you're giving a lift and that friend of yours is going to supply, then you are involved in the supply of those drugs. Of course, if you didn't know about that, then that's your defence. But it's not an easy defence, is it? especially if you're involved in that group of people who are using drugs and or supplying it. So you have to be extremely careful.
Now, if the police take my phone, which I imagine is quite common, what kind of digital evidence are they actually looking for?
Oh, John, I think that that's quite obvious, really, isn't it? The digital evidence that they're looking for is somebody saying, can you lay me on? Can you deliver this amount to me? How much will it cost me? What time will you be there? And lots of people think that, well, I'll use an encrypted telephone messaging system. But if the police get one person's phone, they get access to everybody else that's using it. And if you're saying that you're going to supply in some way, then clearly that the evidence is going to be there. Lots of people think they're going to use abbreviations in some kind of code, but it's ridiculous because it's quite obvious when you add it together what you mean by H or green or white or powder or H for home or those kind of abbreviations. When the whole sentence is read and the police arrest, then they're going to know. Typically, if you're a dealer, they will already have had intelligence, so they already know where they're going with it. But do they have automatic right to access your telephone? And the answer is no. I've already said you shouldn't be volunteering your PIN or your passwords. You should only do that if your solicitor advises you to. So again, make sure that you're speaking to a solicitor. And if you are going to be giving the codes, then you can expect the police to find what is on the telephone. Will this happen quickly? No. Typically, the police will have a very quick scan through the phone. If they find something of relevance, they may pause an interview whilst they go away and have a look at that and then come back and continue the interview to ask you questions about what might be on your phone. And the reason for that, of course, will be you may say, well, those other people are these. And you might then give names, which means the police can go off and arrest other people. And that brings us back to a part of the question that you asked earlier, John. If the police turn up at my house to arrest me, how might they know? Well, they might know because they've arrested somebody else that's given them your information, or that other person has unlocked their phone for them and they've seen your details. So you can see that all of this ties together in that regard. Again, you need to be extremely careful what you're saying to the police and always get a solicitor.
So even messages that don't seem obvious could be interpreted in a certain way?
John, of course, if you stop somebody on the street who has got absolutely nothing to do with criminality, nothing to do with drugs, and their text messages are saying, I'll meet you at the park and we'll go to the shop and we'll buy some dinner and we'll go home and then we'll watch, I don't know, an abbreviation for something on Netflix or Prime or whatever, and that's abbreviated in some way, then it's really quite easy to pick out. But if you are involved in any criminality, then that mix of standard let's go shopping language mixes in with your abbreviations for drugs and supply, and it really does stick out quite a lot, and the police will very easily be able to pick out what's been spoken about. And of course, if you're talking about people about the supply of drugs, then it's going to be easy to see. You're not going to hide it in some kind of abbreviations of text messaging. If the police have arrested you and you don't want them to see those messages, don't give them the PIN. If the police get the PIN, either because they've threatened you under the correct notice that if you don't, then you will be committing another offence, or you do give them the PIN, then they see those messages, and then of course you have to be prepared to answer for that. That's the truth of it, isn't it? If you're committing a crime, you've got to be prepared to answer to it.
If I've been arrested or interviewed, what happens next? Because I imagine that's the point where things can feel quite uncertain.
Well, when you are arrested, you'll be at the police station. And of course, then you will have your solicitor, which I just keep going on about. Have your solicitor. But at the end of the interview process, the police will then decide whether to give you bail or not. The starting point is that you should get your bail. The only time that would be in question would be if there was a risk you'd interfere in the course of an investigation. So if the investigation is still ongoing and they're still tracking down people that you may have been connected with, you might be kept in custody, or you might be remanded into custody, which means remanded means go to prison until such time as your bail is given to you or you have your trial. So if you do get your bail, which again, I remind you, that's the starting point. You should get your bail. And by the way, under the change recently in the law, it is you should get your bail unless it is the case that you're going to be getting, or you may get, a custodial sentence after a trial. So if any of those elements aren't there, for example, protecting the course of an investigation, then you should get your bail. Bail is the police saying, we trust you to go back out whilst we're investigating what's going on, but you mustn't commit another offence. Don't get involved in this investigation and don't breach the law again, certainly not during this investigation or bail period. If you do break the law again whilst you're on bail, then that's an aggravating factor which could result in you being kept in custody. Of course, you can only be bailed for a certain period of time, and in that regard, it may be that you come to the end of your bail period, the police are still investigating, and they release you under further investigation. They can do that right from the police station without bail. What that means that the police have then got a little bit more time to get on and investigate without worrying about the bail criteria or the bail dates running out. But it certainly doesn't mean that is no further action. And I do get asked quite often, or told by some clients, look, nothing's happening to me because they let me go from the police station without being on bail. That's not the truth. They're still investigating until such time as you are told there's no further action. Or, of course, you receive your summons to go to court, or you're charged at the police station. So be very careful to understand what's going on around you.
One of the biggest concerns people have is the outcome. If I was found guilty of a drug offence, how serious could the consequences be?
Well, of course, that would depend on what the quantity is of the drugs and whether it's an A, B or C drug, because the more serious the drug, the higher up the category it is. I have to tell you at this stage, John, that if you plead guilty early, and early being the first attendance at court, you'll get 1/3 discount off any sentence that you might get. Some drug offences means that you have to go to the Crown Court and they're indictable only. Some are either way, meaning they can go to the Crown Court or they can be dealt with in the Magistrates' Court, or some are just summary only, which means they can only be dealt with in the Magistrates' Courts. And then you can see where that's going to go by looking at the sentencing guidelines. And anybody can do that. You can type them into Google, sentencing guidelines, possession class A drug, for example, or possession with intent to supply. And then within that, you'll see that there are lots of drop-down tables. It talks about what the offence is, the maximum and the minimum periods in custody. It also talks about fines, discharges, etc. Then it talks about the aggravating factors. And I spoke a moment ago about committing an offence whilst on bail. That's an aggravating factor which makes things worse overall. Aggravating would be use of force, threatening people, violence, perhaps not your first offence, the amount of the drug that you have, and of course the category of it, A, B or C. So those are aggravating factors. Mitigating factor would be you've admitted it. You're really sorry. Perhaps this was your first time. Perhaps you're in a little bit of financial problem and you just genuinely thought, well, I'll just sell this little bit that I've got, and in which case I'll just be able to pay this week's rent or whatever it might be. And in which case, when you're honest about that, that would be a mitigating point. So a mitigating factor would be where you're able to tell the court, look, my first time, I'm really sorry. I only did it for this. Here is the genuine thoughts that I had at the time, and I understand it's wrong. If, of course, you've got a drug problem and you realize now that you need to break this, and you go and take some courses and you start taking treatment and you get help for that, that's definitely a mitigating factor, because the court can see actually you're putting yourself on the road to recovery. You're looking for help, and there are lots of places where you can get that help. So overall, when you're looking at the consequences of either being in possession of drugs, which gets you to court, or possession with the intent to supply, you need to be extremely careful. You can go into custody for possession with intent to supply. The emphasis nowadays, John, we hear it all the time, don't we, where lots of people aren't being sent to prison. Well, that's right, but you'd be a fool to rely on that if you thought, well, I'll just take up some drug selling over the weekend just to make a bit of money, and it's okay, I won't go to prison, it's my first time. You can't guarantee that. Before being sentenced, if there's a possibility of a custodial sentence, then a court may send you for a pre-sentence report with probation. And probation will interview you, and they'll understand the circumstances of your criminality and your offending, and then they'll set out some recommendations for the court. But believe me, that option of going into custody is still there. The magistrates have got lesser sentencing powers, but as I said earlier on, some cases must go to the Crown Court, and if that's the case, the Crown Court has got some very strong sentencing powers that you need to be very, very minded of before you go down the road of supplying drugs to anybody. Know what you're doing and know what the consequences are, and don't drift into criminality.
Thank you, Michael. So finally, if I came to you as a client facing a drug allegation, what would you actually be doing behind the scenes? Where do you start when building a defence?
Of course, if you came to me and you're asking me, John, about a defence, that means that you're going to be pleading not guilty. Of course, only you know if you're guilty or not. Doesn't matter what the evidence says. Overall, if you haven't done this thing, you haven't done it. And you should never plead guilty to something that you haven't done, regardless of the encouragement with the reduced sentencing. So if you haven't done something, you haven't done it. And the way that the law works, and I'm asked often, why do I defend guilty people? I don't. My clients are only guilty after they've pleaded guilty or a court has found them guilty, and in which case we deal with the sentencing the way that the rules set out. But until you're found guilty or you plead guilty, you're innocent. And I will work very hard indeed, as will all other lawyers, to find that area where the police have not properly investigated, to find that area of the evidence where you can say, actually, this demonstrates that I'm innocent. Will the police disclose that to you? Yes, provided you follow the rules and set out the correct documentation in the defence statement, for example, then the police have to disclose to you all the unused material. Of course, it's down to your lawyer and how thorough that person is going to be as to whether or not you find the chink in the prosecution case. But if you're innocent, that chink will be there, and you need to really go after it. You work hard with your clients, and that's what I say to the lawyers that I train and the lawyers that work with me. Work hard with your clients. They know what they've done and what they haven't done, and they'll be able to tell you where they were at this time and why what the police are saying is wrong. And you need to really extract that. Take your time, and you need to think about it. But just remember that the prosecution have got to, before the court, be beyond reasonable doubt in their evidence. So any doubt that's reasonable will be in the favour of you, the defendant, and that's what you're looking for. Does it work? Is there one knockout blow? Usually no. Usually it's a whole sequence of events that you use in the run-up to the alleged offence or during the alleged offence that when you add them together doesn't quite make sense the way that the police or the prosecution would like it to read. We get a lot of this. You have to take your time. You have to pick it apart, and for that you need to work with your lawyer. And, of course, if you can afford a private lawyer, they may have more time to spend on it. But you need to do that. You need to work with them. Be honest with your lawyer. And then, if there is a chink in the armour of the prosecution case, you'll discover it. You'll expose it. If you expose it earlier in the defence statement and it makes good sense, then actually the prosecution can reassess the case. And your lawyer can ask them to do that. If there's some evidence which really disrupts the prosecution case, the defence team can say, look, we point this out to you and we think that you need to have another look at it. And it may be at that stage that the prosecution think, actually, it's not in the public interest to carry on, or we're not sure now that we're going to get a conviction at the end of this, and they can drop it. You can make an application to the court, and you can have that evidence tested long before your trial. So you can make an application to strike out the claim against you and have it discontinued. And you can do that, but it means that you've got to disclose all of your evidence as the defence. And if you're not successful in that, John, it may well be that what you've just done is you've taught the prosecution what your defence is going to be, and that will make your job harder because they can then go and fill the gaps in the prosecution. But even if you wait until the trial, the prosecution go first. And at half time, we call it, which means when the prosecution has finished their evidence, they've called all of their prosecution witnesses, you can ask the judge to reassess the evidence. And if there isn't enough evidence to carry on, then you don't then move into the second stage. And the jury can be directed by the judge, or the magistrates can make the decision that the matter shouldn't continue, and the matter can then be withdrawn against you, or a not guilty determination entered. Of course, you can, at your stage of the defence in trial, not give evidence. You can just sit back. You can let the prosecution set their case out, so present their best case. And at the end of it, you could say, I'm not giving evidence. I don't have to, because the prosecution have not made out high enough the burden of proof to demonstrate that you're guilty. And that's a direction that the judge will then put to the jury, and also the magistrates will have directed to them by the clerk. Is it wise not to give evidence? I think not. I think if you're innocent, if you've not done this thing, then really you ought to give evidence. You ought to stand up and you ought to say, I didn't do this. Those drugs weren't mine on that table. They belonged to somebody else. And simply because I sit in the same room as somebody else, that doesn't mean I'm guilty of either possession of those drugs or possession with intent to supply. And that should be your case.
The key takeaway from today's episode is that drug allegations are rarely as straightforward as they first appear. From the moment the police become involved, there are multiple layers, evidence, procedure, and legal thresholds, all of which need to be carefully examined. If you find yourself in that position, getting legal advice early can make a significant difference to how your case develops. If you need advice, you can contact our team by phone or through the web form on our website. Thanks for listening to Straight Talking Law.